Hi, my name is Jim Selbach. I am a consumer protection attorney. I've been practicing consumer law for over 36 years. This video is aimed at people who are being pursued by their creditors or debt collectors for debts that they owe. And it's a training video, and it's going to equip you to effectively deal with debt collectors. It's going to give you knowledge of the law. It's going to give you knowledge of the strategies that are used by these debt collectors. And it's going to give you strategies to use when you have to interact with these folks. There's many things that you don't know that you are going to know at the end of this video that's going to make it much more effective for you when you have to deal with them. So let's start out with the first proposition, kind of a personal philosophy of mine. The debts are valid, I'm assuming they are, and the debt collectors have every right to contact you and try to collect those debts. Nobody's arguing about that. They have the right to do that. What they don't have the right to do is harass you, lie to you, bully you, mistreat you, or treat you with disrespect. And as you'll see in a few minutes, federal law protects you when it comes to those rights. You have the right to be treated fairly. And after you see this video, you're going to be able to act in a way that they're going to be forced to treat you in a way that the law requires. So this is a system, and if you follow this system to a T, and you do everything I say, you follow the strategies, you're going to be in control when these debt collectors call you. So there's really two requirements that we're going to be talking about today. The first is you have to have knowledge of the law. There's a great body of law out there, and I guarantee you that these debt collectors know what the law is. Most people don't, and that's why they get pushed around. When you get done with this course, you're going to know the law as good or better than any debt collector. Also, there's strategies, and we'll talk about that as well. Strategies that are intentionally being played against you when they call you. And most people don't even know that. But by knowing what these strategies are and how to contradict them, that's going to put you in charge. So it empowers you. Most debt collectors, when they call, they're in control. They push people around because people don't know their rights. When you know your rights, you know the law, you know the strategies, you're going to be in control. It's a big difference. So how does this work? Well, there's a couple of federal laws that we're going to be talking about. The first one is called the Fair Debt Collection Practices Act, or as we use the term, FDCPA. It's a federal law, and it gives you all kinds of rights, and it prohibits all kinds of conduct by debt collectors. So we'll go through this list. It provides you with all kinds of rights that you have when a debt collector is contacting you. Also, there's also a list of things that debt collectors are not allowed to do. And we'll go through that list as well. This is the most important thing, I think. The way this law is written, it gives you the ability to hire a competent and experienced consumer lawyer to represent you at no cost to you. If you had to pay for a lawyer, you could not afford to battle every one of these creditors, especially if the amount of the debt is relatively small. What the law does is says that if they violate your rights, or if they do one of the conducts, one of the activities that they're not allowed to do, and they violate this law, that violation allows you to bring an action against them, a lawsuit, and they have to pay your lawyer. So that allows you to enforce your rights without incurring any legal fees. Now you get actual damages. So if there was something that actually resulted as a result of their violation, you get that. In addition to that, you get $1,000. Attorney's fees, we talked about that. They have to pay your lawyer. So you don't have, at least with our office and most consumer lawyers, you don't have to put any money down. You don't have to front any money. Really, you never pay us anything. If there's a settlement or if there's a jury award, the money comes out of that. You never pay us. All right, so what are the rules? Let's go through all of the rules under the FDCPA. Let's first talk about telephone calls, because that's the most common way that debt collectors interact with consumers. They call you on the phone, and there's all kinds of rules about telephone calls. First, they may not contact you at any inconvenient time. What does that mean? Well, it could be you're a mother with a small child, and there's certain periods during the day where you're either nursing the child or the child's sleeping. If you tell the debt collector, look, it's not a good time to call me between these hours, and they do call you, that's an inconvenient time and it's a violation. And any time that they call you before 8 a.m. or any time after 9 p.m., the law says automatically that's an inconvenient time. And any other time that might be inconvenient. It might be a holiday, could be a birthday. If it's inconvenient for you to speak with them, they can't talk to you during that time. Inconvenient places. Debt collectors aren't allowed to talk to anybody, with one exception, and we'll talk about it. They're not allowed to talk to anybody else except you, okay? So, if they're not allowed to call you or call other people other than you, they can't call you at other locations other than your house, okay? So, neighbors, friends, relatives, they can't call you at those locations. It's an inconvenient place. What about calls at work? That's really common. Debt collectors know that that's really a form of harassment. You don't want to be bothered at work. It's embarrassing. You could get fired. They know that. That's why they're calling you at work. What's the rule about calling at work? Well, it's pretty simple, really. If the debt collector knows that your employer does not permit personal calls at work, they cannot call you there ever. So if you get a call at work, you don't have to argue with them. You simply say, look, my employer does not permit calls at work. Please stop calling me at work. That's all you need to say. Don't get pulled into an argument. They may do that, but you're just repeating your rights. I'm not allowed to take calls here. You can't call me. Now, after that, if they call you at work, violation. Location information. What's that? A debt collector may call a different location, a different person, if the sole purpose is to try to find you. Let's say you're a younger person and you were living with your parents, but now you've moved out, you got your own apartment. They don't know that. They call your home and they say, we're looking for James. Is he there? As long as they don't identify themselves as a debt collector, don't indicate that they're calling about a debt and they just calling to find you, they can do that. But this is a very limited exception, okay? The whole purpose of it is to locate you. They can't talk to the person about your situation or the debt or any of that. They just can say, my name is Mr. Smith. I'm looking for James. Now, here's the key. They can't identify themselves. They can't tell the person why they're calling. And once they get their answer, they have to stop. Okay? So if they say, well, no, James doesn't live here anymore, or there is no James here, they got their answer. Okay? They can't keep calling, or they can't go further into it. Well, it's really important that I talk to him. The purpose of trying to locate him has been reached, and the call has to stop. Anything further, violation. Now, here's the only exception to speaking to other people. That's speaking to a spouse, okay? The FDCPA does allow a debt collector to speak with a spouse about the debt. So if you're married to somebody, they can discuss that debt with the spouse. All right, here's another law. This is really powerful. This has to do with phone calls to cell phones. It's the Telephone Consumer Protection Act, or the TCPA. And here's what it does. It makes illegal to place a call to a cell phone using an automatic telephone dialing system or an artificial or pre-recorded voice. Most large debt collecting companies use this equipment. And you may have received a call, this is so-and-so, if you're John Smith, press 1 now. It's a pre-recorded voice. It's a machine. How does it work? The computer system in the debt collecting company is calling constantly. It may call you 3 or 4 or 5 times a day. Nobody's sitting there actually dialing a number. The debt collector is sitting at his or her desk. As soon as the computer makes a connection, you pick the phone up and say hello, the call is then prompted, it goes to the debt collector, and then the live person gets on the phone. That's an automatic dialing system. If they're using that system to call your cell phone, it's a violation. Now, the law says if you gave them express consent, probably not applicable. Most people don't realize that they're getting these phone calls on their cell phone from a machine. And they certainly haven't given their consent to do that. So unless they gave consent, it's a violation. Now here's the good part. Every call is $500. And if these machines are calling you 4 or 5 times a day, you can see how the numbers can add up. And if it's willful, it's $1,500 a call. Willful would be if you got on the phone and said, look, I know you're using a machine. I know you're calling my cell number. You need to stop doing that. I don't consent. If they call you after that, that's willful. Now we're up to $1,500. And just like the FDCPA, they have to pay your lawyer. You don't have to put anything down. You don't have to pay the lawyer. Keeping a good record. This is critical. Keeping a record of what occurs so that you can give that record to your lawyer makes your case so much easier to prosecute. And it's evidence. And there's easy ways to make that record. Extremely important. The telephone log that you should have, if you don't have it, you can go to our website and download it. You keep that phone log by your phone with a pen or pencil. And as soon as the call is completed, it only takes a couple of minutes, and the call's fresh in your mind. Date and time of the call, who called, what did they say, what did you say, just jot it down. Every call should be put in that log. And once you have hired a lawyer, your lawyer is working on the case, that log is invaluable. Trust me, I've handled hundreds and hundreds of these cases, and I can tell you, the telephone log is invaluable. And this is critical here. This is really important. Take the call. Now, most people do the opposite. They let it go to voicemail. They see the number come up on the caller ID. They know it's a collection company. They don't want to talk to them. But if you're going to use my system, you have to take the call. Don't let it go to voicemail. And we'll talk a little bit about what you say and how you enter the phone log in a couple of minutes. But if you don't take the call, our system doesn't work here. Now, this is really important if you're represented by an attorney. If you're represented by an attorney, you need to let the debt collector know that. And here's why. If you're represented by an attorney and the debt collector knows it, they have to stop all communications with you. Written, oral, text message, email, I don't care what. They can no longer communicate with you. It's kind of like in criminal law where somebody is in custody and they say, I want a lawyer. As soon as they say that, the police have to stop all communications with that criminal defendant. Same thing here. As soon as you say, I have hired a lawyer, they have to stop. And they don't always stop. If in any way that communication continues, either they keep talking to you, or maybe in a couple days later you get another notice from them, they have violated the law. Here's some examples. Bankruptcy filings, huge area here. And you could be either you have filed bankruptcy, or maybe you've hired a lawyer and they're in the process of putting your paperwork together. Either way, you're represented by a lawyer regarding that debt. And you tell them either I have filed bankruptcy, I have a bankruptcy lawyer, I'm represented by a bankruptcy lawyer, or I'm in the process of filing bankruptcy. Either way, you're represented, and either way, they have to stop talking to you. Sometimes people will hire a lawyer to send letters out to their creditors and try to work something out. Same thing. You've hired a lawyer. They can't talk to you. So what do you do if you are represented by a lawyer in any capacity regarding the debt? Well, first of all, you tell the creditor, the debt collector, that you are represented by an attorney. That's important. Come right out and tell them. And you give them, this is my lawyer's name, this is my lawyer's phone number, and you need to call my lawyer. Do not get pulled into any debate or conversation. This is all you need to tell them. And you're going to repeat what I call your script, and we'll get into that in a few minutes, over and over. You're not debating these people. That's very important. If the conversation continues after you've told them that you filed bankruptcy or you're in the process of filing bankruptcy, or however you tell them that you're represented by a lawyer, it's a violation. All right, harassment, huge area here, because some debt collectors are respectful, professional, but others use harassment as a way to try to get you to pay this debt. And the law does not allow that. So let's look at that for a few minutes. Any conduct that is harassing, oppressive, or abusive is against the law. Okay? Now I realize that's pretty broad, because many things are harassing, oppressive, and abusive. So how do you know that they violated the law? Here's a good rule of thumb. If you think you're being harassed, you probably are. Most people, just using your common sense, know when someone's really trying to harass you or when someone's just being professional. You'll know. Abusive language, not permitted, okay? Just because you owe a debt, it doesn't mean that you have to be subjected to abusive language. And the FDCPA makes it illegal. Any language that is intimidating, belittling, insulting, or profane is against the law. Sometimes they'll be very insulting and put you down. Why don't you pay your debts? What's wrong with you? That kind of thing. Against the law. Threat to contact third parties. I'm going to call your boss. I'm going to call your parents. We already talked about it. They can't do that. So a threat to do something that they can't do, violation. Threats of violence. Or any threat that they're going to do something that the law doesn't allow them to do. Illegal. Failing to identify. So you get a call and the debt collector doesn't identify themselves. What are the rules regarding that? Well, first of all, they may use an alias. So, hi, this is James Jones from ABC Collection. James Jones, probably not their real name. That's for the protection of the debt collector, so people can't go after them, I guess. But they must identify their company. So they can say, I'm James Jones, when I'm not really James Jones. But they have to say, and I'm calling from ABC Collections. If they don't identify themselves, they're violating the law. So what do you do if you get one of these jokers who won't identify themselves or their company? Hang up. Okay? If they call you back, you tell them, look, I don't talk to people on the phone that won't identify themselves. I'm sorry. Goodbye. Okay? It's a very reasonable request. I mean, if you won't identify yourself, I have nothing to tell you. I have nothing to discuss with you. So if that happens, just hang up. False, deceptive, or misleading conduct. Another huge area, okay? Trying to trick you or tell you things that aren't true. Absolutely illegal. Any conduct that is false, deceptive, or misleading in any way is considered to be a violation of the FDCPA. Again, very broad area. Many things can be, false, deceptive, or misleading. Now here's the important point right here. They're going to be telling you many things on the phone, and you may not know if these things are true or not, but I guarantee you, if you have a competent and experienced consumer lawyer, your lawyer is going to know. That's where the phone log becomes so important, because you can jot down, debt collector said blah, 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 okay? And we see this, and we look at, we're looking at these cases, and we say, he said that? Yeah. Well, we know that's not true. Now, you may not know it, but your lawyer does. That's why the phone log is so important. Because a lot of these things that these debt collectors are telling you just aren't true. Here's some examples. And there's all kinds of things that they tell you that isn't true, but here are some ones that we see all the time. And this one cracks me up. I don't know why anybody takes this serious, but some people do. If you don't pay this debt, you're going to jail, okay? Look, that's ridiculous. Debtors' prisons went out about the 15th century. Nobody goes to jail because they don't pay their debts. So if they tell you that, I would just laugh. That's ridiculous. You don't see it a lot, but once in a while. Statute of limitations. A statute of limitations says you have a certain period of time to sue, or you can never sue. For example, in the state that I practice, New York, the statute of limitations for debts is 6 years. So if 6 years has come and gone and you haven't sued, you can never sue. So if they call you, say, in year 7, and it's been 7 years and they've never sued you, and they tell you, we're going to sue you, false statement. Why? Because they can't sue you. Violation. Authority to sue. Some debt collectors do have the authority to sue you, others don't. But if you're talking to a debt collector who has no authority to sue and they threaten to sue you, false statement. Threaten to contact the employer. You already know that they can't do that. So if they tell you that, that's a false statement. They may tell you, look, you have to pay our lawyer's fees and all of these costs that we're going to add on to the debt. You know, if you pay the debt today, I can make you a deal, you won't have to pay the lawyer's fees. Unless there's a specific agreement that you agreed to pay lawyer's fees, you don't have to. And if they tell you you do, false statement, violation. Huge area right here, okay? You filed bankruptcy, the case is over, you listed all your debts, you got a fresh start, you're going on with your life. Now you get some call from a debt collector trying to collect the debt that was in your bankruptcy case. And this person tells you, you got to pay this debt, okay? You know you listed it, you know you got a discharge, you don't owe that debt, ever, never will, and this guy is telling you, you have to pay it, okay? False statement. This happens a lot nowadays because what happens is, when you file bankruptcy, the original creditor may sell that debt to a debt buyer, and now they're calling you. And these are not nice folks, a lot of them. So they're going to try to harass you into paying a debt that you filed in bankruptcy. We get a lot of these cases. Violation. All right. Any statement about your rights, or even the rights of the debt collector for that matter. If they're telling you, look, you don't have the right to do this, or we have the right to do that, be very suspicious, okay? Because it's a pretty good chance that what you're telling them isn't true. That's why, again, write it in the phone log so your lawyer can look at it. Again, your lawyer knows what your rights are, even if you may not know. Some debt collectors will come out and say they're a lawyer when they're not. They might imply that they're a lawyer when they're not. If they do that, it's a violation. This is another area we see a lot of activity. We're going to come take your car. We're going to come take your furniture. Unless they have a lien on whatever they're claiming to take, which is probably unlikely, they don't have any right to repossess. And if they tell you that, false statement. False, deceptive, and misleading. All right, the phone log. We talked about that already, okay? It's very important. Again, it lets your lawyer know what happened so that you can be sure that whatever statements are made can be analyzed by your lawyer. You fill it out as soon as you're done with the call, okay? Just keep it right by your phone. Let me go back to that. You don't have to write a huge dissertation, okay? Just notes. I told him I filed bankruptcy. I told him I had a lawyer. He said blah, blah, blah. Just jot it down. Put it down, forget about it. Once you've contacted an attorney, you give him the phone log. It's gold. All right, let's talk about the dirty little secret. Here's the dirty little secret. When a debt collector calls you, there is a very specific strategy that he or she has in mind. Nothing that they say or do is by chance. There's a plan, there's rules, and here's why it works. You're in a game and you don't even know it, most people. There are rules to that game that you have no idea what the rules are, and you get caught up in it very easily. So, because you don't know the rules and because you don't even know you're in a game, they take immediate control when they call on the phone. Everything that they say is done on purpose. This isn't off the cuff, okay? It's on a very basic strategy. And here's the strategy. They want you to get emotional. Why? Because when people are emotional, they don't think well. They don't think well on their feet. They're not rational. That's why they will insult you, use derogatory terms, belittle you, use abusive language. It's not because they're a jerk. They might be a jerk, but they're doing it for a specific reason. Once you get upset and you respond with emotion, they got you. And they're going to win every single time. That's the game. But here's what we're going to do to prevent that from happening. We're going to make them play your game. You're going to have a strategy. You're going to have rules. And you're going to force them to play your game, and it's going to completely defeat them. How does that work? Here's the trick. I'm going to give you a script, something that you need to say. Very short and sweet. And you just keep repeating it over and over and over. Almost like a robot. No matter what they say, no matter what they do, no matter what they threaten, you just keep repeating your script. Drives them crazy, and it's very effective. So what do you say? Well, I'm represented by an attorney. My attorney's name is, my attorney's phone number is, you need to call my lawyer. That's it. That's the script. If they continue and they start trying to get you upset, well, you're a deadbeat for not paying, you just keep repeating this. You don't say anything else. You don't want to say anything else. You just keep repeating this. Same thing if you file bankruptcy or you're in the process of filing bankruptcy. I filed, I have a lawyer, call my lawyer. Or I'm in the process of filing, call my lawyer, okay? And you just keep repeating it, as I said before. Once you say that script the first time, as we talked about earlier, they have to stop. And if they don't, they've already violated the law. But for you to control that conversation, you just keep repeating your script. It'll bring a quick end to the conversation, I guarantee you. Again, we talked about that. So here's some typical responses that our clients have reported to us when they do give their script. I don't have to talk to your lawyer. Well, actually you do, but they'll lie to you. I don't have to talk to your lawyer. They do have to talk to your lawyer, but they'll say that. What's your response? Do you say, no, you have to talk to my lawyer? No, you just repeat your script, and you'll see why in a minute. I have no record that you filed bankruptcy. So what? If you filed, I don't care if you have a record, I filed. But again, you're just repeating your script. Until you actually file, I can keep talking to you. We hear that a lot. That's not true. But again, repeat your script. Your lawyer has to call me, and until your lawyer calls me, I can keep calling you. Nonsense. Your lawyer doesn't have to call them, and your lawyer's not going to call them. I know many bankruptcy lawyers, and they're way too busy. They're not going to call a debt collector, and they don't have to. Until I receive official notice of your bankruptcy case, I can keep calling you. Nonsense, not true. But here's the important part, okay? You don't argue with them. You just keep repeating that script that I told you. And what does that do? The debt collector knows that 99.9% of people are going to get upset. They're going to argue. What did you call me? And get all upset. But when you start robotically just repeating your script, they realize my strategy isn't working with this person. What works with all these other consumers is not working. They're going to want to get off the phone. They're going to keep saying, are you going to keep repeating that? Yeah, I am. So it's a strategy. Use it. You'll find it very effective. Now, if you have an experienced consumer protection attorney and you do everything that we told you, you're going to be very effective in dealing with your creditors. If you don't, and you live in the state of New York, we would be happy to look at your case. You can call us at our office here in Syracuse. You can send an email if you'd like, or you can go to our website. Our website has a tab that you can fill out a short form, and we'll get an email and somebody will get right back to you. So I hope this was helpful to you. You have a good day.